Hello everyone and welcome to today's Mondac webinar in association with Garfinkel Immigration Law Firm, who will be providing valuable insights about the immigration changes that could impact your businesses and workforces during the second Trump administration. My name is Dan Sampaio and it's my pleasure to introduce today's hosts. Colleen Molner has more than 10 years of experience assisting professionals with the immigrant and non-immigrant visa process. She is the head of Garfinkel Immigration Law Firm's Healthcare Specialty Practice Group and is certified as a specialist in immigration law by the North Carolina State Bar, the highest level of specialization attainable in the state. She also works with companies on workplace compliance and I-9 audits, best practices and policies. Nam Douglas has practiced immigration law since 2011 and is certified as a specialist in immigration law by the NC State Bar. She has extensive employment-based immigration experience, including the preparation of HLO and TN visa petitions, as well as with green card applications, including national interest waivers and the PERM process. She also has experience in the family-based and humanitarian immigration sectors, as well as with workplace compliance and I-9 audits. Before I hand over to the panel to begin today's webinar, a quick housekeeping item. You are able to submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during the Q&A session at the end, but please do reach out after for any additional information you may require. It's now my pleasure to hand you over to Colleen and Nam to begin. Thank you.
Thank you so much. It's such a pleasure for us to be here today, and we look forward to sharing with you our insights, taking your questions, and offering you our best advice as we begin this new Trump administration. As noted, we're with Garfinkel Immigration Law Firm. Our firm is in its 28th year. We are one of the largest firms in the Southeast that's dedicated specifically to the practice of immigration law. We represent businesses and individuals from more than 50 countries, and that spans everything from Fortune 100 companies to small companies with just a few employees. We've represented companies across industry sectors such as energy, manufacturing, pharmaceutical, technology. And as noted, we also have two specialty areas focused on the healthcare sector as well as education. And again, we're thrilled to be here with you today to offer some insights. Noted a previous disclaimer, obviously the information we share today is for general information purposes, is not intended to constitute any specific legal advice. Obviously, we would be happy to discuss your specific immigration needs or specific detailed questions for you outside this webinar, and information on how to contact us will be available at the end of the presentation. In terms of our agenda today, we want to first talk through a little bit about the first Trump administration as well as the initial weeks of the second administration, what we've seen, what we anticipate, and some thoughts on how you can begin to navigate the upcoming changes. We want to spend some time talking about worksite compliance, and again, this can impact any type of business, any kind of business community, and how you can best position your company to address these potential issues as they arise. And then some strategic and tactical recommendations on how your company can prepare and begin to put into place some ideas to manage the upcoming changes and what we may potentially see over the coming months of the administration. And then, of course, have some time with regards to questions and answers. Next, please. So I wanted to take just a brief minute to talk about the prior administration's immigration actions and what that looks like as a roadmap for what we may potentially see with this current administration. During the last Trump administration, he issued more than 400 executive orders that really impacted every aspect of legal immigration. And so from what we've seen over the last several weeks, we anticipate similar types of strategies and actions will be taking place. What those executive orders impacted, and again, what we've already begun to see is one, executive orders and actions that restrict entry into the U.S., limit immigration benefits, impose additional requirements and changes to adjudication protocols for visa classifications, increases to potential wage requirements for the H-1B visa program as well as the green card process, extreme vetting and case review for all USCIS as well as State Department actions, and then significant increases in workforce enforcement against individuals and companies. And we'll take some time to dig into this in a little bit more detail about what we saw more specifically within these areas. Next, please. So restricting entry and immigration, and what we've already seen with regards to this under the second Trump administration is some recent executive orders. And again, this will impact global mobility for companies who are working with individuals coming in and out of the US, and also will also impact current employees that you may have who are traveling international either for work purposes or for personal reasons. So again, there was an executive order regarding a travel ban. We saw several travel bans during the last administration. While there was some travel restrictions tied to COVID, outside of that, we saw restrictions and bans used against specific countries in response to international agreements or lack of agreements across a variety of issues. So we are looking for new travel ban reinstatements no later than March 21st. And again, this would prevent entry of legal visa holders from disfavored countries. We saw a little bit of this play out just in the last week with Colombia. While there wasn't a travel ban based on interactions, there was a closing of the U.S. consulate in Colombia, which again, for all intents and purposes, serves to limit any new individuals from seeking the travel requirements and stamping necessary to come to the U.S. So we anticipate that we'll see more of this over the coming weeks and months, and again, has been a tool previously used, in response to various global actions and country negotiations. Enhanced vetting. So this an executive order has already been issued, and it applies to all government agencies. What that translates to and how you see that is additional administrative processing, more background checks, additional questioning of individuals who are seeking visas at U.S. consulates abroad, as well as potential increased vetting for USCIS and other applications submitted within the United States. What we see sometimes with this is increasing 221G notices. So individuals are seeking their travel visa stamps, which is their travel document to the United States. These are required even if a petition has already been approved by immigration here in the US. If individuals have not previously held that visa classification, they must receive a visa stamp from their US consulate in order to travel to the US. Increased administrative processing requires sometimes additional information, re-examination, additional background checks. This can be challenging, particularly for individuals who may have a common name. If someone with their name appears on a list that requires additional vetting. So again, this ultimately slows down the ability of individuals to come into the US. We've also seen executive orders regarding federal hiring freezes as well as return to work orders. What we anticipate this will result in is obviously a decrease in the number of staff persons across the US government, and again, across all of the agencies that impact and have a role in immigration processing. As a result, again, there will be a slowdown of work by virtue of just less people to process even minimally the same amount of applications. This will delay both internal processing of applications through USCIS, and again, in terms of those having to process outside with less Department of State officials, the number of visa interviews that will be granted will be decreased. So again, this will delay all of the processing we anticipate both in and out of the US. And then we've also seen a removal of the focus to include restricted protected areas from ICE. So memos now allow ICE to enter schools, hospitals, and as well as courthouses. So for those of you who may work in the healthcare industry, work with hospital, work with schools, again, this will impact your day-to-day business, your preparation, worksite compliance and enforcement protocols that Colleen will tell you a little bit more detail of how to prepare for those. We're also anticipating some new executive orders. This could roll back visa waiver and stateside visa issuance. These were efforts under the last administration to again speed up the processing by allowing individuals who have certain eligibility criteria to skip that visa stamping interview process, and also roll out a program that would eliminate the need from certain individuals to have to travel outside of the US to renew those visas. We may also see halts and delays in terms of online filing for USCIS, our internal immigration systems. A concerted effort has been made over the last several years to increase the opportunities to file online, which again expedites the process and allows increased speed in certain adjudications by eliminating that mail going through the mail room and having to have individuals to go through those applications, scan them, and get them to the adjudicating officer. Last time, we also saw pauses in premium processing. Again, we anticipate that this may be another tool, the result which is to slow down the process. Require more in-person interviews. Under the last Biden administration, most employment-based visa individuals had their visa interviews waived for their green card processes, as well as many applying for family-based petitions. Under the last Trump administration, we saw the requirement of every person to have an interview. And again, with staffing shortages, that just means a longer wait as there are fewer individuals to carry out these mandatory interviews. The last item I'll note is obviously there's been a lot of discussion about the US-Mexico-Canada agreement, installation and now pause on tariffs, and question as to whether we will, the US will remain part of that agreement. If we were to no longer participate in that agreement, the TN visa classification, specifically for Canadian and Mexican nationals, may be impacted if there is no ability or if that agreement no longer holds. Next, please. In terms of limiting legal options and benefits, we've already seen that take place over the last 2 weeks. For example, the current administration has already vacated the extension of temporary status for Venezuelans. This means that those individuals who are currently on that status in the US have lawful work authorization, may be employed by your companies. Once that expires, they will have no longer any ability to extend that TPS status. What that means is if there's not another visa classification they're eligible for, they would fall out of legal status and not be able to renew their work authorization. There was also ending humanitarian parole programs for Ukrainians, Afghans, Haitians, Nicaraguans, Venezuelans, and Cubans. Again, these are all individuals currently legally in the U.S. with work authorization. There's an estimate that roughly 30,000 individuals a month since 2023 received these classifications. So again, from your perspective as employers, these are individuals you may currently have as employees who came to you with valid work authorization, who may not be able to extend that. There is obviously the possibility of eliminating DACA. This has been in the courts since the last Trump administration. While there have been numerous efforts to pass legislation, the current environment is not one that I would anticipate something would be able to be passed in the short term. And so whether the judicial protections hold for DACA remains to be seen. There was an interest in removing H-4 work authorization under the last Trump administration. That's more than 100,000 individuals, again, who have work authorization. That may impact companies as well, should that be taken away. There was some discussion of rolling back STEM OPT. This is the program that allows individual international students who graduated with a STEM degree to extend their optional practical training for 2 additional years. Whether or not there is a renewed effort to eliminate or roll back is something we're certainly keeping an eye out. And re-emphasis, reimagining using merit-based systems with economics means testing. Again, parts of this policy was rolled out during the last Trump administration, and so we're keeping an eye out whether these new adjudication requirements will come into play. Next, please. In terms of some of those adjudication protocols, again, what we saw and anticipate is additional requirements and protocols by the USCIS, which is the benefit granting arm. So a little bit of positive news is that the Biden administration was able to, through federal regulation, install the deference to prior adjudications. What this means is that USCIS should defer to its previous adjudication of an application. So if there is no changes to job position or title with an extension, USCIS should defer to that approval and have a smooth approval of that extension process. It also means, because this is now part of the Federal Register, federal policy, it would be more difficult for the Trump administration to roll that back. They would have to go through a formal process of notice and hearing in order to remove that. What we do potentially anticipate is increased costs and requirements for H-1B. While there is new regulations around specialty occupation, it does narrow the definition. So with extreme vetting and additional protocols, we do anticipate some additional levels of requests for evidence, possible denials as well. If the administration also pursues increases to the wage rates for H-1B and PERM, last time this amounted to a 30% increase, which obviously for employers would have significant hardship and also reverberations throughout their workforce. When you tie immigration into equal protection, obviously if H-1B workers are required to be paid 30% higher to be a software engineer in your Charlotte office, then U.S. citizen software engineers in your U.S. citizen business office in Charlotte would be required to have that same wage as well. We also anticipate additional scrutiny on third-party site locations for contractors. These would be individuals who are working at those sites on H-1B, L, but also for international students through their OPT. We also anticipate some additional challenges for international students. Again, potentially more hurdles, both in terms of that visa stamping process, potential rollback of some protections that we saw last year based on their duration of status entry into the U.S. And then again, anticipating more interviews that are required for all visa types. Next, please. So all this results in what we anticipate to be more delays and backlogs. Again, we expect case adjudication to slow down. We saw a fairly significant increase and a slowdown under the last Trump administration. We anticipate, again, with the combined potential impact of a decreased federal workforce, that we can anticipate that all case processing will take longer. We also anticipate that the U.S. government will not extend a prior settlement that allowed for dependent visa to be adjudicated along with principals, especially those under premium processing. What this means is it creates gaps. So you may have your dependent visa holder approved while their wife and children's applications remain pending for 2, 3, or 4 months. It also means for visa holders who have work authorization, the potential for gaps in work authorization become increasingly high. As a reminder, extensions cannot be filed more than 6 months ahead of time. We're already seeing regular processing for H-1Bs exceed 10 months. So again, this creates the potential for work gaps for H-4, and for employers to even have to be mindful of their H-1 and L visa holders to ensure that they don't exceed the 240 days past their current work authorization that is allowed by regulations. We are hopeful that we will not see a rollback of the issuance of 5-year work authorization cards. Again, there was some statutory regulations that hopefully will allow this to continue. But again, this is a potential area of rollback. We also saw under the last administration that L2 and E2 dependents no longer had to apply for work authorization, again, which allowed them to enter the workforce and to maintain their work authorization in a much more streamlined fashion. It is certainly possible that this could be rolled back. And again, if they have to apply for that work authorization card, there's the potential for gaps in work authorization. Changes to the citizenship exam, these were floated last time. Again, this would only impact those at the end of their immigration history, but could potentially impact the need to continue renewing green card status. Next, please. So is there any hope or good news? Certainly you've all seen that the issue of high-skilled immigration has already created some tensions, as there are various members of the Trump administration and special advisors who have differing views on the value of high-skilled immigrants and how we can ease their ability to secure work authorization in the U.S. So ideas that have come out are, green cards for those with advanced degrees in STEM, streamlining that process, addressing the green card backlog, particularly for high-skilled workers, possibly increasing the H-1B cap. Obviously, we don't know how those various voices and who will end up on top, but certainly we're hopeful that we may see some positive movement in that regard. Next, please. I'm going to turn it over to Colleen now, and she'll talk a little bit more in depth regarding worksite compliance.
Thank you, Nam. In terms of worksite compliance, what we're talking about is a company's adherence to, all applicable laws, regulations, and standards within your workplace, ensuring that operations follow proper procedures for employee safety, data protection, labor practices, and other relevant areas. So Essentially, what we're talking about in this portion is increased oversight of worksite compliance, meaning that employers are conducting business ethically and legally at their worksite, including in their hiring practices. So many of you are likely aware that employers are required to verify employees' work authorization and identification as they're onboarding new employees. That's through the I-9 process. The government will audit. A lot of times they do it randomly, or sometimes they do it on an anonymous tip. They will issue audits to certain organizations and companies to ensure that they have completed their I-9s correctly, from a technical perspective, but also from a substantive perspective, meaning that there are no unauthorized workers at your worksite, that you have not knowingly hired an undocumented or unauthorized employee at your worksite. In the event that you do, or you have violated from a technical perspective or more substantive perspective, then you are subject to fines, criminal, civil penalties. We saw during his first administration that there was an increase in these audits issued by ICE. They are issued through a notice of inspection. Again, it can be done randomly, or it could be done in response to an anonymous tip. We are expecting those to increase. We have seen and heard that a lot of companies have already been subject to some of these notices of inspection. So from that respect, it's important to make sure I-9s are in order, audit them internally. We'll talk a little bit more about that later, but auditing them internally to make sure that you are not subject to violations, or if so, that they are very minimal from the technical perspective. We're also expecting more site visits from an arm of the Department of Homeland Security, or USCIS. That is from the Fraud Detection Unit, a National Security Unit. They have the authority to come to your workplace, especially if you're an H or an L or even an R religious worker worksite. They have the authority to come to your worksite, and the purpose of them coming to your worksite, again, unintentionally announced or unannounced, they'll come to your worksite to ensure that your H and L employees are there working pursuant to the terms and conditions of the H and the L petition that were approved. So they're looking to ask questions of an HR representative and or your H&L employees to ensure their salary, they're working at the work site that's been approved by the Immigration Service, and that they're doing exactly what has been laid out to the Immigration Service. So we're expecting more, or an uptick of those visits. Again, they're usually unannounced. Sometimes they're coming just to check on one H employee or L employee. Sometimes they're coming to check on a handful of them. We're also expecting more site visits from ICE for companies that employ F1 students on STEM or OPT. Typically, folks who are employed on a STEM OPT training plan that is approved by the Immigration Service. And so we are expecting that ICE, when they do come to these employers, they are doing similarly to what FDNS does with H's and L's. They want to interview the student worker and also the manager, just to ensure that the student is doing everything that's been laid out in the training plan at the same work site that was approved for, being paid what they're supposed to be getting paid, etc. And then we're also expecting an increase in criminal enforcement actions against contracting firms and end clients, which in turn, encourages whistleblower actions by private citizens. What this means is that government agencies like ICE, they're going to be more actively investigating and pursuing legal charges against, more contracting firms and their clients. So their end clients, where they're placing their contractors. We're expecting investigations there and charges for those who are knowingly hiring or utilizing undocumented workers, which can lead to criminal penalties for both parties if violations are found, meaning for the contracting firm and also the end clients. This is common in the H-1B realm, is to have H-1B employees working at an end client or third-party work sites. So essentially, we're expecting that businesses from the worksite compliance perspective, possibly facing legal consequences, really for not adequately verifying the immigration status of their employees or their subcontractors if they're using them. This could be across various sectors, not just constructive or active labor industries, but various sectors, as I mentioned, even H-1B employers. It could also mean not properly completing I-9 forms or conducting adequate background checks to verify employment eligibility. So again, it all ties in to ensuring that you are documenting how you are verifying work authorization and identification for your employees, whether it's through a contracting firm or your own employees. And then finally, we are expecting increased investigations by the DOJ and EEOC of U.S. worker discrimination for those who are or allegedly have hiring practices where they are preferring foreign workers. Next slide, please. Another big aspect of worksite compliance, if you hire or employ foreign national talent, is in the H-1B realm. There is a whole practice area for H-1B compliance. And if you have filed H-1B petitions, you are likely familiar with a lot of the requirements involved with sponsoring an employee. With H-1B compliance, we're talking about the government ensuring that the employer is adhering to all of the legal requirements that are set by the government when hiring an H-1B employee, including ensuring that the job qualifies as a specialty occupation, that the employer is paying the prevailing wage as determined by the Department of Labor, and of course, ensuring that you're filing all of the necessary paperwork with the Immigration Service to sponsor that employee. It's important because failure to comply with these regulations, it can result in penalties. It could result in other legal issues, and then of course, denial of future H-1B petitions. As part of the H-1B requirements, employers are required to post a notice of labor condition application, which notifies folks that you are sponsoring an H-1B employee, and it gives contact information if there are any complaints in violating the program. You have to post that notice before filing the petition and document that it's been posted. And then you also have to file a labor condition application, which, as noted on here, ensures that the employee is working at a worksite location, and then also being paid the required wage by the Department of Labor. All of this, along with documentation that the employee is being paid the appropriate wage, it all gets compiled into what's called a public access file, or a PAF. We prepare those for our H-1B employer clients with instructions on where to house them. They have to be available for an inspection if requested by the government or the public. Some of the documentation that's required to be in this includes that notice that I mentioned, also a signed copy of the LCA, proof that the employee has received a copy of that LCA, summary of employee benefits, the wage documentation, and also documentation as to how you come up with that wage if it's higher than the prevailing wage, and that it's the same wage that's paid to other similar employees. So the Fraud Detection and National Security Unit that I mentioned earlier, the FDNS, when they come to your work site to do a visit on H-1B employees, they're going to look at these public access files, and it could be for just one employee, or it could be for a handful of them, or all of them. So it's important to have these public access files, making sure that they are put together properly, that they have all of the required documentation, and that they are accessible in the event that there's a worksite visit to your office. Next slide, please. So some of the recommendations in order to prepare for these worksite visits I've mentioned, but of course you want to, if you're an H-1B employer in particular, You want to make sure that you are reviewing everything that you have on file, review the public access files, know who has them, so that if there's an officer who comes to check in, you need to know who to refer them to give access to the public access files. Do an internal audit of them. Do an internal audit for your I-9s as well. You could do all of them, or you could do a handful of them just to see if there is a trend and any errors, which might lead you to want to do even more audits internally. You also want to ensure that you're compliant with your state's E-Verify requirements. Every state has its own requirements, so ensuring that you're aligned on that as well in the event that there's a visit or an audit. You also want to have a plan in place in the event that you have a visit from FDNS or ICE or Homeland Security investigations. We generally recommend preparing by having at least one designated representative and ensuring that all of your colleagues are aware of who that representative is in the event that there's a visit, and they can refer the officer to that person to handle what the investigation is about, whether it's for an I-9 audit or for an H-1B employee or L employee, student employee. That person can be tasked with overseeing the site visit, but also gathering any of the required documentation, getting immigration counsel on the line, etc. Also recommend that those who are involved in your immigration program, in particular, and any managers of foreign national employees, have some internal training to ensure that they are aware of what the immigration compliance means and involves on the H-1B level. You want to ensure that they understand the specifics and also your responsibilities as an employer for that particular visa classification. It doesn't have to just be for the H, but for all of them. Especially, this is important, especially if there's a visit from, ICE or FDNS coming to investigate an H-1B or an L employee. They want to talk to a manager or one of your colleagues about what that particular employee is doing. They need to be familiar with what was filed with Immigration Service and what is required for that particular visa category so that their responses are aligned and consistent. Of course, we'd recommend talking to immigration counsel, for support on general internal policies in terms of immigration policies, your public access file policies, putting together an internal I-9 audit or an outside I-9 audit to prepare in the event that you do have one of these notices of inspection, but also having a policy and a program in place to train your colleagues internally and ensure that everyone is prepared in the event that you have a visit. They know who to refer to and to help facilitate that overall worksite visit. And of course, knowing your rights under the law. This is a little bit of a complicated one. The government, you've heard a lot of what's going on in the news about ICE being able to visit, as Nam mentioned, churches, schools, hospitals, etc. Unless they have a warrant, they cannot go into a private area. So in general, I think putting one of those trainings together internally for your staff and your colleagues, along with knowing your rights under the law, can really help making your folks feel more comfortable in the event, and knowing what to do in the event that there is a worksite visit. Next slide, please. So how do we prepare now? We have put together some tactical and strategic recommendations in light of all of these changes that have already rolled out or sort of rolled out over the last couple of weeks, and what we're expecting. If you are proactive with a lot of the preparation, then it could mitigate some of the consequences and violations that you would otherwise be subject to. So some of the tactical recommendations we would recommend, if you have any employees who you want to employ long-term, if they're currently here on an H or an L or a TN, and you want them to be here as a permanent resident and sponsor them for a green card, file those prevailing wage requests sooner rather than later, because we are anticipating that wages are going to go up under this administration. Those typically set in July. July 1st is when the wages are redue. With processing times right now for prevailing wages, it's possible and likely that you might not get a wage request under the current wage levels if you started right now, but it's something that you could endeavor to do nonetheless. Upgrade any pending petitions with the Immigration Service to premium processing. As NAM mentioned and alluded earlier, we are expecting a lot of delays and backlogs given a number of factors of things that are going on, including the hiring freeze and less federal government workers. So we're expecting petitions to take a lot longer. So if you upgrade your cases to premium processing, get a quicker decision, this could help with assurance, peace of mind for your employee, but also your managers. And then it could also minimize any disruptions in the event that it pens for way too long, and then it eventually gives a gap in employment for your employee. Identify colleagues from countries that will likely be impacted by the travel ban. So looking at the countries that were impacted under the previous administration, run some reports in your systems to see if you can identify any who have the same nationality and might be subject. Warn them not to travel, especially as we have yet to hear what the travel ban is going to entail, which is expected by end of March. We also recommend updating your site visit protocols, have some internal training, as I mentioned before. It would be a good idea to partner with Immigration Counsel on that, just to ensure your I's are dotted, T's are crossed, and you have everything in place in the event that there's a site visit, whether it's an FD&S visit for a certain employee, HRL program, or for I-9 visits. Oh, and as I just mentioned, audit your I-9 compliance. Prepare for this to be required to move to a U.S. location. So, as I mentioned before, doing an internal audit on either a handful of them or all of them, see what trends come up. That would lead you to possibly need to redo all of them. Again, this proactive approach could really help minimize or elude any sort of violations. And then also reevaluate any positions that you have internally and also petitions that are being sponsored for those positions with an eye towards Buy American, Hire American. So this was under his first administration executive order, really showing that the position is in order to get through Immigration Service, really showing that it is one that propels our national interest over hiring an American. So we're expecting that our cases that are filed with Immigration Service and even at the Department of State, we're expecting that the officers are going to be evaluating petitions with that sort of approach and mindset. So partnering with Immigration Counsel to ensure that you are preparing those cases and thinking about, a lot of what the challenges might be raised from that perspective. In terms of strategic recommendations, again, because of the anticipated travel bans coming up, we would recommend finalizing any international relocations as soon as possible, just to avoid any delays or issues in the event they are subject to the travel ban. Under the first administration, they did have an exemption for the travel ban for certain work visas if the position was in the national interest. That was known as a national interest waiver. We don't know if that's going to come along with the travel bans, but it's possible. But in any event, those were difficult to have approved. They were challenging for some companies to make that case. So if you have any that employees that need to be in the U.S. this year, start that process now. Brief managers and other business leadership on the impact of mobility. So talking internally about everything we've talked about today, what to expect in terms of global mobility and how it could really impact their workforce plans, come up with some contingencies in the event that they do have employees from some of these subjected travel ban countries, or they do have employees who, might be subjected to a disruption in work authorization due to lengthy processing times. Just being aware of what's going on. If certain departments or business units do employ foreign national talent, that's very important to have that sort of communications plan and internal discussion for contingencies. We'd also recommend evaluating your current policy, if you have one, on employee relocation. So during the first Trump administration, when we saw a lot of delays and backlogs, employees were losing their work authorization. They had to depart the U.S. So a lot of companies were looking at employing their employees at a different affiliate outside of the U.S. Depending on your company, your policies might not allow that, or they might. So look at that in alignment and in discussion with managers and other business leaders so that you know whether or not that is an option in the event any of your foreign national employees in the U.S. Are in one of those situations. And then finally, we would recommend revisiting any vendor resource management support that you use, like third-party contractors. Really evaluating that and ideally with immigration counsel or their immigration counsel, just to ensure that they are compliant with their visa-sponsored population and also, work documentation and eligibility, because as I mentioned earlier, we are expecting that there's going to be increased enforcement over that particular area, which puts not only the vendor at risk, but also you as the end client. So opening up that conversation with your vendors is important in identifying strategies to proactively tackle any potential issues. Next slide. Now for individuals, everything that I just mentioned was really from the employer perspective. Individuals can also prepare now. We do recommend, if you have any employees who are on any type of parole document, to travel with extreme caution at this time, if at all. If they don't have to travel, don't travel. This is because one of the executive orders essentially put a pause or a halt on some of the humanitarian parole programs. And there's been a lot of confusion at the border when foreign nationals are traveling with one of those parole documents. They're either really challenging them on their reentry and whether or not they can reenter based on that executive order, or they're not allowing them reentry. And it's causing a lot of delays at the border. We've heard a lot of stories at the Canadian border, folks coming in. But it's important for you all to know this too, because you might have employees who are in the green card process, and while they're waiting on their green card, they might have an advanced parole document. And that parole document is being scrutinized at the border right now because it looks the same as the humanitarian parole document. So there's been a lot of confusion by the CBP officers at the port of entry and at the borders in terms of who they can let in with these parole documents. So if you have any employees on any type of parole document, either don't travel, or if you do travel, do it with extreme caution because they might not be let back in. Review any travel plans for with your employees for 2025 and beyond. Again, preparing for delays in any visa stamping if they need any to get back in, and any other restrictions such as travel bans. Individual employees, if they have EADs, so an employment authorization document, and discretionary immigration benefits, like if they're working on DACA or TPS, if those are expiring in 2025 and eligible to renew, do it as soon as possible. As soon as that renewal window opens, we are expecting that some of these programs may not be extended or renewed this year. They may be terminated. So having done that as soon as possible might protect you in the event that it's eliminated. If you are on an EAD, especially DACA, TPS, or H4 EAD, and eligible to move to another category like H1B or L, do that. If the company is willing to support that, again, that could protect you in the event that one of the programs that you're currently employed under is eliminated or paused. And then finally, obviously, of course, partner with immigration counsel. Right now is a very difficult time, I think, to navigate in immigration. We are There's a flurry of executive orders and policies. We're still waiting to see how some of it unfolds in practice, but being able to call on immigration counsel and partner with someone should give you some support on status options, opportunities, let you know what's going on, and be able to help you from there. Next slide, please. That brings us to our questions and answers section.
Thank you very much, Colleen. And before we move to our Q&A section, I would just like to say a big thank you to Colleen and Nam for your insights today. It's an incredibly important subject, so it was a very informative discussion. So we thank you for that. So we'll move to our Q&A session now. We have a question just to address. I think, Colleen, you covered it just then. Do you anticipate there will be an impact on visa holders returning to the US if they travel to other countries? And I think the advice would be just to review travel plans. Would that be correct?
Correct. Possible travel bans upcoming that were expected based on the text of one of the executive orders, expecting those to roll out by March 21st. So keeping an eye on that and monitoring, get any travel done now if you have to travel.
Brilliant. Thank you very much. So I'll take this question. And if you do have a question now, we have 10 minutes or so. Please do send that in and we'll be able to put it to the panel. So could the I-9 form take greater significance or increased penalties for failure to complete correctly?
So what Colleen shared was we do anticipate increased I-9 audits. So from a greater significance, I would say just in terms of potential opportunities for an investigation. It's sort of an initial entry into looking at a company's books and employees and compliance. And if there are a lot of irregularities, that would potentially create the opportunity for ICE to launch a further investigation or evaluate some type of criminal liability. In terms of the fines vary from like $300 to $3,000 per technical deficiency. So it is a harsh reality of, every checkbox that isn't checked out or information that's incorrectly filled out does open the company up to those fines. Those are preset fines currently outlined. I don't necessarily anticipate that civil fines will increase, but more that I-9s will be used as sort of a starting point to investigate businesses and their hiring practices.
Excellent. Thank you for that, Nam. Brittany has just asked, what about employees on TN? Should there be consideration on moving to another visa status like H-1B in the event there are changes in the Mexican-US-Canadian agreement?
Sure. So obviously this is an area of a lot of uncertainty. We saw the sanctions put in and then rolled back for a month. We have, chatter about leaving this trade agreement. So we really don't know what will happen. If your company is willing to put you or consider an H-1B, or if there's an L option, I think certainly those statuses are much more stable and unlikely to have the same potential for impact. Obviously, with the H-1B, I'm sure you're all aware there is a lottery because there are more individuals who want those than there are visas available. If you want to act and add people to the lottery, companies need to do it now. That window that requires pre-registration for the lottery will open in March, and there's no latitude on those dates. So if you are seeking to add individuals to the lottery, again, those on TN, maybe those on H4EAD, now would be the time to reach out to immigration counsel or your internal immigration team.
And I'll also comment, if you do have TNs, particularly Canadian TNs, given the pushback that we have already seen at the border, in that we saw during the Trump administration, it would be best practice to file those TM petitions through the Immigration Service and get a pre-approved approval notice that they can then take through the border rather than having the CBP officers adjudicate them at the border, putting the employees through, some sort of rigorous interview. Having that approval notice should flag them right through the border rather than going through a tough interview with the officer.
Brilliant. Thank you both. Richard has asked, are there any specific considerations for green card holders?
I'll say, really, I think delays is the biggest consideration. I think we're just going to see that the issuance, if it's been filed, if your application for a green card's been filed, I think we're just expecting to see major delays and backlogs, which raises the importance of maintaining some sort of non-immigrant status if eligible, if the employee is also eligible for H or an L visa. Ensuring that you're maintaining both statuses in the event that the green card takes so long, you have a backup status on the H or the L to minimize any disruptions to employment. And then also the travel factor. So many green card applicants have that parole document. So just traveling with extreme caution on that document for the time being. If they have an H or an L visa, they are allowed to, again, maintain that classification and travel on the H or the L versus that parole document. Nam, I don't know if you have anything else to add.
I would just briefly add, one, if you are already a green card holder and you're eligible to naturalize, we always encourage that process. Even being a green card holder for extended periods of time does not ultimately protect you in the event of some incident or some situation that might arise. So we do encourage you to naturalize if you're eligible. And then for those waiting green cards, I also think we do not anticipate a lot of movement in the visa bulletin. So for those backlog categories, again, if there's an option to look for and maintain your underlying status, for companies, you may want to consider starting that green card process sooner, depending on your internal processes, to give folks as much time as possible to make their way through.
Brilliant. Thank you very much. So I have a question here, and it may be slightly difficult to answer right now. It's could be a case of looking into your crystal ball and seeing the future with policies that haven't been implemented yet. But the question asks, how might the immigration process between Canada and the United States be affected by policies implemented during the second administration?
So I think we touched on it. I was going to say, I think we touched on it a little bit in terms of the potential availability of TN visas going forward, extreme scrutiny at the border by CBP officers. I think for in terms of changing requirements and narrowing the criteria for TN, what we've seen is those professional categories have not changed. So they're very traditional, right? You're a biologist, you're a chemist, you're an engineer. The reality is much of the workforce positions are not always that cleanly defined. But CBP could revert to looking very narrowly at job duties and job titles in terms of those adjudication. So as Colleen mentioned, perhaps looking to file with USCIS as a way to eliminate, some of that pushback at the border. Colleen, did you have anything else to add?
You covered it.
Brilliant. Thank you, Nam. Well, looking at the time, I think we will need to wrap up there. But once again, I would like to say thank you very much, Colleen. Thank you, Nam, for your insights today. As I say, a lot of very important information presented very clearly, concisely. We really appreciate your time. We hope that we can have you back again soon. Thank you also to our audience for being with us today. You can see on the screen, it's been on the screen for the last 10 minutes or so, Colleen and Nam's contact information and that QR code. So please do get in touch if there are any questions that you have that you'd like to speak in a bit more detail with our panelists today. So now, Colleen, if there are any sort of closing thoughts that you have, please do share those now. Thank you.
Thank you, Dan, and thanks to Mondak. We appreciate the opportunity. As Dan mentioned, if you have any questions or concerns related to your immigration program or certain employees, feel free to reach out to us. We're happy to partner with you during this time.
Yes, thank you so much for having us. We look forward to working with Mondak. And again, as Colleen mentioned, any of you who we might be able to assist, please don't hesitate to reach out.
Brilliant. Thank you very much. Have a lovely day, everyone. Goodbye.
Take care.
Thanks.